Hello and welcome to the BRR Legal Brief, where we bring you the latest legal issues affecting corporates in Australia. Today we're looking at James Hardie with two High Court decisions handed down last week. We're going to look at the decision and of course the implications. Joining me to discuss is Liz Boyce, who's a partner at DibbsBarker. Liz, thank you so much for joining us.
Kate.
Well, as mentioned, late last week, the High Court handed down two decisions which found that the non-executive directors and as well the General Counsel were liable for their role in allowing an ASX statement to be released. Before we look at the implications, what are some of the background details?
Sure. This case really goes back to 2001, where the James Hardie Group was looking at splitting out two of its subsidiaries that had substantial legacy asbestos liabilities. It was agreed to create a new fund, which would have what they hoped would be adequate funding for the claims. Mm-hmm. They engaged external advisors to work out if the funding was going to be adequate, but it was clear that there was never going to be a hard answer on that question. However, when it was announced to the market, the statement to the market simply said that the new fund was fully funded. Now, as time went by, it became very obvious that that was not the case, unfortunately. ASIC took action against all of the directors and a number of senior managers. Mm-hmm. And in the first instance in the New South Wales Supreme Court, the court found that those directors and officers had breached their duties. They hadn't acted with care and diligence in putting that announcement together, and therefore they were liable. The non-executive directors and the General Counsel and various others appealed. At the Court of Appeal level in New South Wales, the Court of Appeal said, had you approved that announcement, that would have been a breach of your duties. But we're not satisfied that ASIC has actually proved that. ASIC didn't call the external lawyer who'd been part of crafting the minutes and been at the meeting, and the Court of Appeal said that that was essentially a fatal flaw in ASIC's evidence. And so, by virtue of that, the directors were relieved. ASIC then appealed to the High Court, and the High Court said, well, it's not clear that had you brought in that extra witness that he would have changed anything. The minutes stand as a business record that the announcement was tabled and approved, and therefore that means that the directors who approved it and the General Counsel who was involved in it were liable. Well,
they were found to be liable. Do you reckon non-executive directors should now be on notice?
Well, this case illustrates that you really, in a sense, die or survive on process. It revolved around the process of approving the ASX announcement. And I'm sure people watching this would identify with the situation that the directors and managers found themselves in. It was a pressure cooker environment. There was pressure to get the deal sorted out before the accounting standards changed, because that would have affected the balance sheet of the company. There was a desire to announce the transaction at the same time as announcing the quarterly results. So again, time pressure. We can all identify with that. But what this illustrates is that notwithstanding that time pressure, there are fundamental duties that you have. This related to a fundamental obligation of a listed company to keep the market informed. It wasn't an obscure area of directors' duties, and therefore the directors were responsible for the message that went out.
And Liz, if we can now turn to the General Counsel, Mr. Saffron, the court upheld that he had breached his responsibilities and essentially said that he couldn't separate his functions as Company Secretary and General Counsel into neat boxes. What do you think the implications of this decision will be for General Counsel who may be performing multiple functions?
Well, in my observation, many General Counsel have that dual role. Many company secretaries have a dual role, whether it's General Counsel or in finance or management. And the court said that it's that whole role that informs what you do as a company secretary. Under the Corporations Act, a company secretary is automatically regarded as an officer, so they have those duties of care and diligence. The court also said, though, that even if Mr. Saffron had been able to separate out those two roles and distinguish those two hats that he said he wore, he still would have been regarded as an officer. He was one of the top 2 or 3 executives in the company. He was one of the 3 core executives involved in crafting the whole proposal of separating the subsidiaries and creating the new foundation, and therefore he was participating in a significant decision for the company. Although he wasn't the one who actually made the decision, that was made by the board. Under the Corporations Act, you're still an officer if you participate in those significant decisions.
Well, Liz, the General Counsel and also the non-executive directors, as you mentioned, have been found liable. Do you think that this represents a tougher stance being taken by the court in relation to directors' duties?
I think certainly the courts are imposing a very high standard, notwithstanding the fact that directors find themselves with very heavy workloads these days, voluminous board papers, perhaps needing to decide on quite complex matters that may not be within their core skill set. The courts are requiring them to bring their own independent mindset and knowledge to that process. This case, as I said, revolved around a very basic obligation of a listed company to keep the market informed. The Centro case from last year was about another fundamental obligation to issue correct financial statements. So they're not obscure areas, but the court is certainly imposing a very high standard, notwithstanding the workload.
And Liz, just finally, obviously everyone's been watching the decision closely. What are the key lessons you think that we can take from this decision?
Look, I'd probably identify three. One really revolves around the importance as a director to bring your own independent mind to the matters before you. Notwithstanding that you may have an external advisor, if there are matters that are known to you that the advisor doesn't seem to have picked up on, you need to bring those to their attention. If things just don't pass the smell test that you're reviewing, you need to raise those concerns. I'd say secondly, bearing in mind that often decisions are made under extreme pressure, there's a challenge to boards and particularly the chairman to make sure that their process is as best as possible aimed at bringing out any issues with the matters that they're deciding. Giving some space for people to reflect during the meeting, perhaps going around and asking every director to make a personal comment on the matters being decided so that as best you can, you unearth those problems that may be lurking there. And then finally, I'd say as a listed company, it's a reminder that you really need to have a very robust mindset when you look at the announcements that you bring to the market. It's a hard balancing act. You want to fairly reflect both the good and the bad, but often these things are developed over time and edited over time, and you may lose some of the nuances. So before you finally hit the send button, you need to have that one last look at does it actually stand up.
Well, there's some great tips there for business. Thank you so much for joining us today.
My pleasure.
And viewers, thank you for joining us also. We hope that you can join us next week for our legal brief.